Public spaces for employees. We talk about the aspect of being online so much. A lot of us have different types of things. We have YouTube, we have TikTok, we have Instagram, we have Facebook. There's so many different forums that are public spaces. Does an employer have a right to go check those out? If you are being hired for a job, does an employer have the right to go and check those public spaces for you? Actually, they do. They can sit down and look as to what you have on there. I've been in a meeting one time. We were prohibiting employees on interview committees from looking on social media. So right in the middle of one, somebody said, "Oh, look at this! They're doing this." Okay, you're not supposed to be online during the interview process. You try to keep those things out if you can, except for the fact that no matter what happens, we are so involved and engaged in social media nowadays. It is common for people, no matter what you say for directions, they're going to use that because there's 3.5 billion users, 500 million blogs, 80 million companies, Facebook pages, and 92% use social media in recruiting, and 99% of human resources use some type of AI system to actually screen applicants. 2 million companies have access to Facebook. No, it pervades society. It pervades every aspect of it. And by the way, it pervades our workplace as well. There's a collision of interest, of employee rights, employer interest. And no, you can't fire me over that. Yes, they can. One of the landmark cases out there in a public sector employee was City of San Diego versus Roe, and a police officer was wearing part uniform and engaging in sex on video and out there, and because of the fact he was in uniform, he was terminated, and it was actually upheld in court. You can't sit down there because of the fact you're wearing a public employee uniform and sit down there and degrade the uniform was what the result was. The other part is, don't do it. I mean, seriously, I encourage a lot of students when they're coming through a class to sit down and says, I got this. I said, purge your social media. You don't know if someday, 30 years from now, you'll be up for a Supreme Court nomination and somebody will bring back something stupid that you did back in college. Cleanse your social media. Don't have things on there that are embarrassing today or might be embarrassing 10 years from now or 20 years because it sticks around a long time. However, company policies apply. Personal comments rule, make certain that when you say something and you put it out there, that it can pass the test at work without anybody being upset to the point that you violated something about the employment and embarrass the employer. Make sure you distance yourself from the actual aspect of your employment in the process as well. A lot of times, if you're the employer, make certain you put your privacy policies out there. If it's going to relate to people in the public sector, especially if you have a public employee, put it out there. It extends to the newest technology, so sometimes you may have to sit down and come up with something new. Artificial intelligence is consuming such a huge space in social media today that you almost have to go back and double check to make certain you have that area covered as well. A privacy policy should be clear that employees have no expectation of privacy in all employer provided equipment. That should flash up on the screen nonstop. If searches are contemplated, state the purposes, conditions, and that they won't be fishing expeditions. But if they are fishing expeditions, tell them up front. We'll be looking for the following 17 different things. Monitoring policies should be clearly stated. Avoid content-based or real-time monitoring if you can. But you know what? The employer does have a right. So keep that in mind no matter what if you're the employee. The privacy policy makes certain you should cover use of cameras, cell phones, other devices for taking pictures or making recordings on your property. If you don't want it to happen, put it in writing, and that way you can hold the employees accountable, make them read it. Okay. The use of emails for distributing illegal and improper content. The use of company trademarks, logos, or other copyrighted material without permission. Make certain all that's on there. And about off-duty activities, beware of over-restricting, trying to take the workplace into the other person's personal life. Now, the problem is you have people working from home, and all of a sudden now you have your boss now has a footprint in your house, literally, because you're doing company work, and your home has become an extension of the office. Be careful of that. Does the boss have the right to sit down and intrude in different parts of that? The answer is yes. We even had here in California, because it is California, and we do a lot of really unique things here. We had a bill going through saying an employer can't call an employee at home. Well, that's cute, except for the fact we've been doing that since time began and people had a job. That doesn't matter whether you're a farmer, a technician, or an office worker. We always had that. So it's really hard to sit down and start dividing that. But I understand the concern because of the fact that too often we have this drifting into the private life of people over there. Can you search an employee's property? The answer is yes, if there's reasonable cause. If you believe searches are necessary, your policy should say that. If you have a policy that says that you do not have to have a search warrant to do so. I've had to do it twice now. And it's one of those moments of you show up and everything else, and you say, here's the policy, and you get to go through and look for things that they may have taken from the workplace, and if they do, you have whatever is lined out there depending upon the offense. So pay attention to that. You're always better off to have that. You always have to make certain you have privacy rules that are required by HIPAA, making certain employee health records are not accessible. So that's a big deal. Keep abreast about technology, how it's changing things to make certain that your privacy rules are consistent. Public employees, they're considered to be state actions, and you'll trigger certain protections that they're going to have because of the fact they're not private sector employees and they're not necessarily at will as well. But that said, employee privacy rights have three sources: the Constitution, state and federal laws, and common laws. But for the most part, if it's at work, if it's using company equipment, it's company access, regardless of what anybody has an opinion about. That pretty much is the default aspect of it, unless there's other rules out there that specifically prohibit that. So pretty much employers have the right to monitor employee activity while they're on the property, and employers have a stronger footing if they develop a written policy. You're better off having it in writing. Keep your social media platform reasonable. Reasonable means if a reasonable person looks at it and they think it's being reasonable and not offensive. There's so much out there now, it is incredible as to what people say, and sometimes that can drift into the workplace, not a good place to be. A good policy and writing alleviates gray areas for employees. That way there's no question about it. The employer has the right to monitor workplace activities almost each and every single time, especially if it's in the workplace, with workplace equipment, employer paid for different devices. They have the right to have access to that and to monitor. Take care.